Should we read this whole resolution or just the exhibit itself? You all have the resolution?
We have the resolution for the substance exhibit A, so it's...
Yeah. Would you then call that up on your screens? This has section 3, article 2, is hereby amended to read as follows. Now this first thing I'm going to read you has been there all along. This has been in the bylaws since their existence. And that is authority. A, board members shall have no authority except when functioning as a member of the board in an official meeting. No individual member of the board may exercise authority with respect to the operation of the health care assistance program, public health department or clinic, or the emergency medical service, or the services of Montgomery County Hospital District employees by virtue of their status as board members. Over the past few years, there have been instances of board members riding ambulances and okay, yeah. Why don't you read the proposed change?
This is the new language. What Harold read was the old language. This is subsection B.
It's additional language.
Additional language, yes. Outside of meetings of the Board of Directors, including regular, special, and committee meetings and social events, board members should seek and obtain permission from the board chair before making any requests for information or having contact with MCHD employees other than the Chief Executive Officer, Chief Operating Officer, Chief Financial Officer, or EMS Director. While the board chair shall seek to ensure that the other board members are afforded a robust opportunity to obtain such information as is necessary to perform their official functions and duties as board members, the board chair retains the authority to establish guidelines as to the extent and duration of requests for information to district employees from other board members so as to minimize disruption in the workplace at the district and to curtail harassment as a result of multiple or vexatious requests that are found by the board chair to be brought in bad faith or in furtherance of matters not within the official functions or duties of the requesting board member. Subsection C, board members must follow established MCHD policies applicable to MCHD personnel at all times when on district property, whether owned or leased and/or at a location where MCHD personnel are performing their prescribed duties, except to the extent such policies conflict with these bylaws.
Okay, thank you, sir. Okay, as I said, A has always been in existence. It doesn't seem to cover the instances we need to cover. I agree with all the comments that we received from the public today about board members needing to get information when they request it. If you will notice down here in B, members are afforded a robust opportunity to obtain such information as necessary to perform their official functions and duties as a board member. I think everybody understands what robust means. So there's no reason that a board member would be kept away from that. Some of the problems that we have, or I have, that has started this addition to our bylaws is we have a board member that shows up at an accident and our people are taking care of their clients, the victims of the accident, and they're walking around looking at all this, and a policeman comes up and says, "Would you please move over to the side?" "Well, I don't have to, I'm their boss." That's inappropriate. That's out of line. We have board members that show up at 9, 10 o'clock at night at one of our branches or one of our stations where there are two women by themselves watching TV and stays there till 10, 11, 12 o'clock. That's inappropriate. It's not only inappropriate, it's freaky. Some of these things occurring keep occurring. We have board members that request information from hospital personnel that's in violation of the HEPA Act and could cause great liability and bad publicity to the district. So this is an effort to bring some of those things under control. This is an effort to make things better, not to make them worse. This is not an effort to curtail any board member from performing their duties as a board member and inquiring into anything. You know, school boards members, they exercise and govern a school district. But a school board member doesn't go into a second grade class and sit there in the classroom and ask the students, what is their teacher doing wrong? Are they happy with their teacher? Are they happy with the principal? Are they happy with their superintendent? That's kind of ridiculous. These are some of the things that we are confronting, and this is the reason I'm bringing this to the board's attention, this proposed change. With that being said, I'm sure there's some discussion you'd like to be had.
Let me make a motion that we accept the
Okay, discussion.
May I make an amendment to your proposal?
Sure.
I'd like to make it. One of the criteria is that it comes just to the chairman. I would like to make an amendment that be the chairman or their designated representative, and we amend it that a board member also could bring it before the whole board if they so desire. So that way, if there is any impropriety that is even asserted by on behalf of the chairman or their representative, the whole board would then make the decision. And I want to kind of comment on why I put that in there. I agree. I think that it is the job of the board, and I agree with the public, to oversee what the operations of the district are. It's not our job to micromanage the district. And so I feel that if there are improprieties, or we think there are improprieties, then it's the job of the board in its entirety to address those issues and not go off individually and address those issues and then come to the board and say they've got a problem. I think it's up to the board, entire board, to make that decision. And that's basically what we're saying here. Is come to the board if you have an issue and let us as a board make that decision and see if administration is doing something that is improper. Let us investigate it as an entire body and not individually. Thank you.
There is an opportunity. Okay.
I need a second.
I'll second that.
There is.
Can we discuss it just briefly?
Okay.
Just to clarify, the board can only hear a report or a request from another board member. The whole board can only hear that in a full board meeting. Okay. But you're still good with that?
Yeah.
Okay.
Yes, ma'am.
I am not in support of this at all. As board members, our enabling legislation in section 106.3.103, management, control, and administration, the board shall manage, control, and administer the health care of the hospital system and the district's money and resources. How am I to be held accountable to our taxpayers to give them the information that they have the right to get from me as a board member when I am denied access to that information without having to go through proper channels? The board chairman did not elect me to this position. The citizens of this county did. I serve at large. And my duty is to the citizens of this county. If there are some improprieties by a specific board member, as has been alleged, then those can be addressed on an individual basis. As far as a police involvement, asking someone to move away, the police have the authority to do what they feel is necessary in that circumstance. As far as a school board member walking into a second grade classroom and asking those children any question he or she wishes to, they have that absolute right. And as far as my not being allowed to talk to our employees, if this policy is passed, I will tell you right now, in public, on the record, I will refuse to abide by that policy. 4 years ago, I heard some grumblings, not grumblings, But there were some employees that had some serious concerns about what was going on in Mchd, and they weren't petty concerns. And I had to meet secretly with these people and get them to talk to me. The first meeting I attended, only 3 people were willing to show up. Then the next meeting there might be 5. The next meeting there might be 7. I then invited other board members to go and speak with these people. The employees do not trust the administration in this district, and as a board member, I find that intolerable. Our employees have to feel like they have a safe work environment. They have to feel like their jobs are not in jeopardy if they come and talk to me. If they have gone through the proper chain of command, if they have made every effort to go to their supervisor and their supervisor's supervisor, and they're still not getting any results from their legitimate concerns, then I feel like they have the right to come to me as a board member and let me bring it to the board, as I did 4 years ago. My son was in the hospital after having had a seizure, and I came to the board meeting anyway, and I said, here are the concerns I've heard over the last 2 months. These are serious concerns, they need to be addressed, and if you'll excuse me, I'm going to see my son in the hospital. And guess what? As a result of those secret meetings with our employees, we now have a totally new administration. And with all due respect to our current administration, if we need to replace the administration again, then I am all about doing that. I want to know that I can talk to the employees of this district, hear their legitimate concerns. They weren't petty, they were legitimate concerns. Then I will absolutely vote as a board member to replace the current administration so that our employees have a comfortable work environment. These people go out there and say, what? I am not going to have them be intimidated by administration fearing for their job if they have a conversation with me.
Good job. Appreciate your time. I remember the instance you referred to. I also remember that there were board members that were also aware of that. You didn't take it on yourself to do it by yourself. And you brought it to the board. And that is one of the things that we're asking for here. And that is very important. That is a big, important difference. We also, since that time, and because of that, have an 800 line that goes to a uninterested person where any employee can register any complaint that they have against the administration of this district.
But I am an interested person, and I want them to be able to call me.
I've never heard of that 800 number, and I don't think anybody else has it. Is that true?
That is true.
Where
It's
is
in the
this?
board book today. That's the first time I've heard of it.
I've never heard of
Yeah.
it before.
No, we have an 800 line service that we're putting into the service, but it's not up to the running yet. It'll be up running next week, so we'll advertise it again.
Let me add on to what Georgette had to say. I was part of that, getting the information from and making the change in the last administration. And the only reason was because I went out there and talked to the people, and the people trusted me. They trusted Georgette. There were very few board members that they actually trusted, ever have trusted, or would come to. And part of that was because the last administration decided that they should not have any contact with board personnel, no different than what we have going on right here today. We have one individual in this room that was recently terminated, and the reason that was said was because they were seen talking to me. That's just wrong. But you can make your comments, you can make your faces, whatever you want to do. I'm just telling you what's taking place. I don't approve of some of the allegations that were brought forward. That's neither here nor there. We have a constitutional right to talk to any employee in this district that we want to at any time, and they have the same right. There should be no retribution. If so, that's a violation of their First Amendment rights, and this building is, or this district is open for suit for ACLU. And I would push that 100%, give every dime I've got to be able to make it take place.
I don't see that this is a district matter. This is a board matter. I don't see that there's retribution has he been any part of this conversation. We're not talking about our employees. We're talking about our board members, respecting the other board members before they go out on a witch hunt.
I don't know of any witch hunt that's
There is
actually
no
taking
witch
place in
hunt.
this. And you've got employees that are coming to
Pardon me, I'm
you.
not through. You can approach these things in one of two ways. You can approach it in a constructive manner, or you can approach it in a destructive manner. When you go out by yourself, solicit complaints, and you're talking to an employee, and you say, you know, you got anything you're unhappy about? Well, you know, that job that opened up in front of you, you should have had that job. They give it to somebody else. You should have had that job. That's not serving this board correctly. That doesn't need to happen. And it has happened. And these are the things that we're addressing here, and these are the needs that are the things that necessitated these additions. We're not changing the bylaw. We're making additions to them. We're not restricting any board member's right to talk to any employee. We're only asking that the board be made a part of it.
No, because they're not going to talk to me if everybody knows who spoke to me, because they're in fear of losing their job.
You don't have to
When
tell us who it is, we just want to know what the complaint is.
I've given you a list of
Okay, so
complaints.
I want to
I
talk
gave
to
you 4 pages of
XYZ
complaints.
employee. May I have your
Nothing was
permission to
done.
do that? Then there you go. So it's all sort of moot, right? Because
it's not.
if I don't have to name the employee that I want to talk to, and I don't have to name the topic of conversation, why do I need permission? And I'm telling you, the only people that can take me off the board are those people out there, the voters. And I will not abide by this if it is passed.
Good for you.
Because honestly, 4 years ago, when I had those conversations with those employees, they brought to me valid concerns. I hope I'm not getting anybody fired by saying this. There was a paramedic, I don't know what her status is, attendant, or whatever, and I apologize. She had to transport a premature baby that had life-threatening situations. The bottles they had on the ambulance for babies were too big for this preemie. They almost lost that preemie. She asked the district, could we please put preemie bottles on the ambulances for these babies? They said no. That was a valid concern she had. We've got taxpayers out there that have preemie babies. They want their child to be able to be saved, and if it takes $1 bottle on each of our boxes, I think the taxpayers would support that.
Did you bring it to the board's attention?
No, because I was afraid she would get fired, and it was a previous administration.
Okay.
I'm sorry, I cannot support this, and if it passes, I will not abide by it. I will talk to anybody out there. I will talk to any taxpayer that wants to call me. My cell phone number, I believe it's on the web. If it's not, I'm on Facebook. I have no blocks on my Facebook page. You can contact me directly. I will talk to any employee that wishes to talk to me. I was able to get the information that I did 4 years ago from the employees because they know I can be trusted. They know I'm not going to give them up. They know I'm not going to go tell somebody that I talked to Susie Smith so that Susie Smith gets fired. I am adamantly opposed to this policy. I will not support it.
Well, I respect your right to oppose this, and
I vote on the amendment, and then we'll go to the actual resolution.
Yeah.
Just to stay in some sort of
let's,
correction.
you call the question on the amendment.
Just on the amendment, yes,
Okay.
and we can get back.
Okay, you've heard the proposed amendment. All in favor?
Aye.
No.
No.
Any opposed? Carries 5-2.
I'd like to add something. Number one is, has legal counsel reviewed this resolution?
Yes, I was asked by the board chairman to draft this resolution. The concern that was raised to me was that the board needed to follow the chain of command and expect the chain of command with police from top to bottom, the organization. And the concern was that there were disruptions in the chain of command and somebody doing their job because of a board member or board members not being invited to showing up and disrupting the workplace. I was very careful to make sure when it came to drafting this document, and maybe it's not perfect, but I understand a board member needs information in order to do the job. You all are accountable to the public. You're accountable to taxpayers. You have to make sure that the ship is running smoothly, efficiently, and in a manner that carries out your statutory responsibilities. At the same time, I had a concern, if it were true, and I'm not sure it's true, of people being able to do their jobs and not be interrupted by board members. That's the responsibility of the chain of command. And so the intent on this was to give the board chair the ability, as you'll see in here, to establish guidelines if a board member is acting out of line, if they are simply interrupting with the day-to-day affairs of the district. You all can take that offline with the board member, and I'm not pointing out any individual board member here, but this really goes to your duty to police yourselves and to recognize what your responsibilities are to the taxpayers and to the chain of command that you have here in place. I don't think it's fair for a board member that has a problem about something they've heard not to approach the administration here and tell them to fix it. It's their responsibility, it's these guys' responsibility to operate the district the way I understand the way the chain of command is set up. Bringing it to the board and complaining about it before somebody here has an opportunity to even address it, be aware of it, and fix it, I think is a problem. But the idea that I had in helping draft this, again, at the request of the board chair, was to allow by a bylaw for a board member that was clearly out of bounds to have to understand that there is a bylaw here to bring them back into bounds and honor basically the chain of command structure that's in place. It's nothing more than that. If someone makes one open records request, a board member comes and says, I need some information to do my job, and they get it, that's fine. But what happens if they come back the next day and say, and I need this, and I need this, and I need this, and they do it to prohibit the person from doing their day-to-day job? I think that's a problem. And that's why I put the word harassment and vexatious. Those are different than somebody that needs information for doing their job as a board member. So it's not, and Georgette, I clearly understand the board member needs to be able to reach out to employees to find out if there are problems. But what if the board member is the problem? And they're not invited to that station? That's the concern I have. And that was what I had heard was taking place, and that's why this policy says what it says.
Thank you, sir.
I'd like to add that the intent of this resolution is not, I absolutely not, I agree with Georgette. If we can't have an employee call us and tell us there's a problem, then that's a problem. That's not the intention of this resolution.
It's the effect on it.
Well, it's not the intent. So if it needs to be reworded,
It's not the effect.
or whatever.
Mr. Posey, you're the only person that can grant people permission.
No, we changed that.
Okay, change that.
We changed that.
Okay, I apologize.
We changed that to appoint somebody
When
in
did you
his
do that?
place or the whole board. So you got the whole.
Ma'am, you're out of order.
But
Yeah.
anyway, all I'm saying is, what we're trying to do is police ourselves and do what we know is right. Obviously, this district is well run. Look at, we're the best EMS service in the country. And that is because we've got a board that cares and we've got an administration that cares. Are they perfect? Are we perfect? No. Do we make mistakes? Do they make mistakes? Yes. But look at the people in this room. Look at the people that are recognized. Look at the people that got out of their car off duty to save a life.
Look at the text.
And so how can we not be supportive of doing things that make it easier for these people to do their job? I'm not trying to restrict what they do. I'm trying to make it easier for them to do what they do. I work for a corporation. There's a chain of command when you're in a corporation as to how you approach things. It's no different in government. In government, you have to go through chains of command of things to do. We are part of that. If somebody wants to call Georgette, they want to call me or anybody else and give a legitimate complaint, I'll do my doggonest to make sure that it gets taken care of, and I'll do my doggonest to make sure that person has no retribution for that. And I don't think there's a person that sits on this board that feels any differently.
You can't, because they lost their appeal process beyond the CEO.
No, they didn't.
Yes,
And they did.
This board voted that we have no appeal process.
It may have been before you were on the board, but the
Yes.
employees that are terminated cannot appeal beyond the CEO anymore. And I have a problem with that too, but it's not on the agenda, we can't discuss it, that's up for another meeting.
We should put that on the agenda.
Yeah, maybe it should be.
There's no reason why we can't.
Let's put it on the agenda.
Call the question.
Okay? Question's been called? Okay. All those in favor of the resolution, vote aye.
Aye.
Aye. All those opposed?
No.
I believe it's 5-2. Motion carries.
Boo.
Thank you for giving me this moment of your time. I would like to address agenda item number 10 regarding the proposed change to the bylaws. First, many employees are also residents of the county. As written, the proposed change would prevent residents who are also employees from approaching members of the board to discuss both praises and concerns regarding district operations because they are employees. I believe this change, if approved, would indirectly punish a county resident by restricting their access to our elected officials simply because they are also a district employee. Second, district employees have historically been very crucial in helping to keep the district focused on patient-centric goals. It was district employees who helped bring issues within prior administration to the board's attention so that they could be remedied. In fact, members of our current administration have, in the past, availed themselves of this option in order to effect positive change. Because of these reasons, I believe that the proposed change to the bylaws breaks the employee board member dynamic that we all rely on. It disenfranchises employees and minimizes their involvement, and denies them an option in how they provide input on the direction and future of the district. This is not in the best interest of MCHD nor our community, and I urge the board to vote no on the proposed change. Thank you.
Thank you, Ms. Aaron. Mr. Adrian Heath.
Good afternoon, board members. Thank you for allowing me to speak. I'd like to thank the taxpayers of Montgomery County for making all this possible. My comments today are about agenda item number 10. We can thank the Lord that we do have a Republican form of government in the state of Texas. And a Republican form of government denotes that there is voter control and that we have representative government. Agenda item number 10 comes against the idea of a Republican form of government because it isolates research and inquiry by members of the board, the general members of the board, as opposed to the current chairman or the present chairman, the chairman at any time. That, I think, is a problem. In addition to that, I did some research online, and I found an Attorney General's opinion that does cast some knowledge, I guess, on this question. So I want to read a couple of items to you. This is from 1983, Jim Maddox, JM 119. You can look it up online. And the scenario, of course, Attorney General's opinions are always different. Every situation is different, but we can still glean some guidance from this opinion. And the scenario was a chancellor and a board member. The board member had presented a request to the chancellor for information, and the chancellor wanted to withhold that information. It says here that including a district trustee, records maintained by the community college, when he concludes that those records are within an exception of the open records request. We disagree. This argument erroneously assumes that a trustee's right to access to information maintained by the district is limited to that of a member of the general public. And then it continues, since the governmental body, in this instance a board of trustees of the district, at least constructively maintains records in the district's possession, we believe it logically flows that the member of that board has an inherent right to access to such records, at least when he requests them in his official capacity. Again, I'm taking these out of context. I urge you to go and read them online.
There's a little bit, 1 minute left.
We conclude, when a trustee of a community college district acting in his official capacity requests information maintained by the district, he is not a member of the public for purposes of the Open Records Act. On the contrary, he is a member of the board, which at least constructively maintains all records in the district's possession and is charged with the duty of implementing the Act. So that was around the concept of the Open Records Act. But board members are not a member of the public for the purposes of their official capacity. Board members should have unfettered access, and it would be wrong for any of you board members to cede your power to have inquiry into records of this district to a chairman, any chairman, whether he's a good chairman now or he might be an evil chairman down the road. I urge you to vote against this measure and consider that it could cause constitutional
3
problems.
minutes.
It could cause excessive costs for legal defense of your position. Thank you for your time and attention.
Thank you, Mr. E. Ms. Judy Appleton?
He actually just did very well. We're good. Thank you.
Mr. Dale finished Descendant? Did I say that correctly, sir?
Well, it was a halfway decent.
I made a good college try.
Yes, you did. It's Dale Fessenden. And first of all, I do want to thank you for the opportunity to speak, but also for the service that the hospital district has provided. We have received services very well from the hospital district in the past, and I just want to thank you all for representing me. And of course, my concerns also regard agenda item number 10. I don't know all the background to it, but it seems to restrict access of board members to the people that they are supposed to interface with. And restrictions on access, it sounds counterintuitive to the primary function of the board, which is oversight of the hospital district. How can you have oversight when you have restricted access? So it raises that question in my mind, and I don't know exactly how the employees feel about this, whether they're in favor of this or not. Again, I don't know the background, but it does raise a number of questions, and it does seem counter to the primary function of the board to restrict access of the board members to those that they're supposed to have oversight of. So that's all I have to say. Thank you very much.
I appreciate your comments. Ms. Ginger Russell.
Hi, how are you doing? I'm Ginger Russell. Anyway, I'm also coming in relation to the item 10 on the agenda. I'm just greatly concerned because you're limiting free speech and the right to assembly according to the United States Constitution, which I will read. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people to peaceably assemble, to petition the government for redress of grievances. When I read Resolution 10, I just think it's a violation of the United States Constitution. I think you're opening yourself up for more legal battles if you adopt this resolution. I think it needs to be tabled. Thank you.
Mr. Calvin Russell.
My point's already been addressed.
Ms. Sherry Williams.
Hi, my name is Sherry Williams, and I've been a resident of Montgomery County my entire life. I am currently on the program due to situations beyond my control. I have not had any real problems with that. I don't have a problem with the staff at this time. What I do have a problem with is the board allowing their administrators that they have oversight over to dictate to them to whom they can speak. That is not an appropriate action to take. It also breeds more distrust of this hospital district. Let me briefly recap a 25-year history of the Montgomery County Hospital District Board. Number one, the county hospital was no longer a county hospital. In secret, it was sold to another organization. It is now owned by, I believe, the Hospital Corporation of America. If I'm incorrect, please correct me. The second big issue was when you built this building and you took over the River Point building, and then you built this building, and then you built another Lone Star Clinic. I attended the public clinic the first time. It took me over a year to get a doctor. Now, if one of you cannot go and find out from the person who is the administrator over the public health and find out why, then what redress do I have as a citizen and a person who uses the program to ensure that I'm going to get appropriate care? I have none. Because you have given people that you've hired, and I really think that they're qualified people.
1 minute left.
But I do not think it is appropriate for this board to go into more secrecy and more distrust. Your numbers are down, and your numbers are down because people do not trust the system. And they're going to help it, they're not going to trust it anymore if you allow this to happen. It's a travesty. There's nobody in the world that would allow the Commissioner's Court to not be able to talk to a single county employee. Now, I don't know how you're set up right now, but rest assured I can find out. I would also suggest that you table this until more people are allowed to be made aware of it, other than by a Facebook post from the Montgomery County Reporter. And may I ask, is there a representative from the Courier here today? Good.
3 minutes.
I was not allowed to cover these meetings when I worked for KIKR because I worked for Rigby Owen.
Ma'am, that's 3 minutes.
Thank you.
I would like to make one correction. The hospital district had nothing to do with Lone Star.
Okay, excuse me. Pardon me.